Hello everyone. Today in this video we shall be discussing the recent Supreme Court judgment on divorce. The following shall be the points for discussion today. Now, recently the Supreme Court in the case of Shilpa Sailesh vs Arun Srinivasan held that it has the power to dissolve a marriage if it has been irretrievably broken down by giving complete justice under Article 142 even if one of the parties was not willing. Also, it can waive the mandatory 6-month waiting period for divorce. Now, let us look at the concept of divorce by mutual consent and irretrievable breakdown of marriage under Hindu Marriage Act of 1955. Section 13B of the Hindu Marriage Act provides for divorce by mutual consent, under which both the parties to the marriage must together file a petition to the district court. This will be done on the grounds that they have been living separately for a period of 1 year or more, that they have not been able to live together, and have mutually agreed that the marriage should be dissolved. The parties must move a second motion before the court at least 6 months after the date of presentation of the first petition and not later than 18 months after the said date, provided the petition is not withdrawn in the meantime. The mandatory 6-month wait is intended to give the parties time to withdraw their plea. However, a waiver of the 6-month waiting period under Section 13B subsection 2 can be sought in an exemption application filed before the Family Court. A petition for divorce by mutual consent can be moved only after a year of marriage. Section 14 provides for such an exemption where it allows a divorce petition sooner in case of exceptional hardship of the petitioner or of exceptional depravity on the part of the respondent. Irretrievable breakdown of marriage is not yet a ground for divorce under the Hindu Marriage Act of 1955. The Law Commission of India in its 71st report recommended adding irretrievable breakdown of marriage as an additional ground for divorce. Now let us look at the significant points in the judgment. The court held that the decree of divorce is often time-consuming and lengthy. As per Supreme Court, if there is no possibility of reconciliation, it will be meaningless to prolong the agony of the parties to the marriage. Dissolving such a marriage, even if one of the parties agree, will provide a speedy resolution for parties who are unable to live together and have mutually agreed that the marriage should be dissolved. The court also held that the grant of divorce by the Supreme Court on the ground of irretrievable breakdown of marriage is not a matter of right, rather a discretion which needs to be exercised with great care and caution. The Supreme Court also clarified that the party cannot file a writ petition under Article 32 or Article 226 of the Constitution of India and seek relief of dissolution of marriage on the ground of irretrievable breakdown of marriage directly from it. The 5-judge bench highlighted the need of the Supreme Court to move away from fault theory and accusatorial principle of divorce under Section 13, subsection 1 of Hindu Marriage Act of 1955, which prescribes divorce on grounds where one of the spouses can be held guilty of certain misdeeds such as cruelty, adultery, or desertion. Now let us look at the Article 142 of the Indian Constitution. Article 142 confers sweeping power on the Supreme Court to pass such decree or make such order as is necessary for doing complete justice in any cause or matter. Now, that's all for today. Hope you liked the video. Thanks for watching.